All right. Well, some people will jump back on. That's, I every week have some challenge trying to get my thing up and running every single week.
Can you guys hear? Oh yeah, they can hear you. They're talking to you. Just so you know, you may not be able to see the chat unless, I'm not sure how you can get into it unless you actually go to the broadcast, like through the public end. The Google Hangouts, like it has a little chat box, but it's just me and you that can communicate in this one.
Oh, okay. Yeah, I don't see any chats, but let me see if I can get it on my phone.
Yeah, you'll be able to get it that way for sure.
Okay.
So this is Wendy Hernandez from Command the Courtroom. I'm sure everyone here knows who she is because basically we've been planning this for a while now. So if you don't know who Wendy Hernandez from Command the Courtroom is, I can share my screen and give everybody a quick little demo while you open the chat and stuff.
Okay. And you guys, for whoever's there, I'm sorry because this mess up was mine. I thought Arizona was Mountain Standard Time was at Arizona time, and apparently it's an hour off. So I apologize. I'm a half hour late.
I think half of Arizona or a piece of it is actually Mountain Standard Time.
Really?
Yeah, I do think so. But I've never confirmed this for myself.
Okay. Yeah, I mean, the rest of the country always changes time, and Arizona never changes time. I've never had to change time.
Oh, yeah, that's the other thing.
So
what do they call that again, where you jump an hour forward and back?
Yeah, I've never.
Arizona's weird and doesn't do that. Actually, maybe we're all the weird ones.
Yeah, maybe. Okay, so I'm getting us live. I see myself.
Yeah, I've never. Weird and doesn't do that. Actually, maybe we're all the weird ones.
Yeah, maybe.
You may have to mute. I don't know why it's doing that. It's like echoing.
Can you hear me now? Is it echoing now?
No, it stopped. Oh, it's probably because of your phone.
I turned it down, but now I can't. Oh, there's the chat. Okay. All right, there we go. Oh, hi, Kachi. I see you're there. And Baskino. Good to see you. Hi, Appywright. And Prevent PA. Thank you guys for being so patient. I am sorry. I was walking around here and I was ready except for my lipstick. I don't have my lipstick on today, as you can see, but it's Saturday, so you'll give me a break. Yeah, Arizona doesn't do daylight savings time. Hi, Vivian. Good to see you. Ah, it's Saturday, and I haven't had any coffee, so.
Is your husband there in the background?
My husband's there. We have this, he was a DJ in another life in the UK and Europe. And so he's helped me with the sound setup. So he has this thing he bought for me to help because I told him when I record at home, it's real echoey. And he bought me this thing to kind of, I don't know what it does, but it helps with the sound. So let me know, you guys, if it sounds okay.
Yeah, it seems a little bit clearer. One of the things I wanted to ask you about was if you recommend that people use CPS in the police in your state, because over here, more often than not, when a litigant does that, it backfires. I've seen so many different hearing videos, and I've never seen it go well.
So are you talking about, Alex, if somebody is having issues, and do I recommend that they call CPS? Is that what you're asking?
Yeah. Over here, I recommend people just, if you're the parent, I recommend they just file something and try and deal with it through the court.
Yeah. The thing is with CPS, it can backfire for people because judges think you're trying to go around the court system, for one. And two, at least CPS in Arizona, which is now called the Department of Child Safety. My husband's giving me a thumbs up because he works there. But you know what? They take forever to do anything. It can take months to get any kind of action. You can't talk to anybody. You can't get any reports. So it's often a dead end. If there's an emergent issue that's happening, I do recommend that somebody just, goes ahead and gets paperwork filed on an emergency basis. I don't know how it is where you are.
That's what I tell people too. I was like, there's almost no reason to use them in a child custody case, because if you do have an emergency, you can file emergency paperwork.
Exactly.
And I try to acknowledge what I think it is. I think people are afraid of the court system, and I also think they don't want to spend the money if they need an attorney. And so, you know, picking up the phone, and it's also ex parte, because when you call CPS, it's not like they call your ex and have you both talk to them at the same time. They just take one story. And
Right.
so all these things are really appealing to a litigant. And so I don't think they're really planning it out that way, like they're strategizing it. I think it's just like instinct. But
Yep.
there's also other drawbacks to it, in my opinion, because they have a whole different standard. They're looking for something else. They have a whole different statutory scheme. And
Yes.
your ex gets a free attorney if it does go anywhere.
That's absolutely right.
And
Yep.
then we over here we have clear and convincing evidence instead of the preponderance. So I actually had a viewer that was stuck in the what they call CHINS proceedings. We call them abuse and neglect proceedings over here.
Okay.
And he was getting nowhere fast. And so I told him, try and get out of there, because I don't know how Arizona works, but when their CHINS proceedings are instituted, the court can't do anything. They're just stuck. So yeah, and in fact, there's a process that you go through to sort of consent to that. So try and get out of there as quick as you can. He got out of there, and then he got primary, physical, and sole legal right away.
Okay. Yeah, it's, you know, my experience is that when the Department of Child Safety gets involved, it can be an absolute disaster. And especially if both parents have some quote issues, you know, or you know, if the Department of Child Safety latches on, and sometimes they can really target people in a case, you know, then you see kids ending up in foster care, it's a tragic thing.
Yeah. So true. And in his case, one of the caseworkers ended up trying to testify against him when he left the CHINS proceedings.
Yeah.
And she followed him to the ordinary family court and testified against him. The judge rejected her testimony, but geez.
Oh my gosh. Yeah, I'm with you 100% on that. And also, you know, as it relates to orders of protection where somebody wants to include the children for a certain reason. I don't know how your system works where you are, but we have different courts for orders of protection and then our regular family court.
Yeah.
So if, you know, your ex has done something that you think is endangering the children, you know, I always tell people, let's just have the family court judge handle it, because if the family court judge thinks you're trying to go around him or her by going to get a restraining order, that's not going to be good for you either.
That backfires here too a lot. That's not the thing it used to be. In the old days, that was like a strategy. Over here, that's not good, especially like you said, when they include the kids. Because I've seen multiple hearing videos. We have a bunch of them on YouTube. We have organizations that post these. They're not supposed to, but they post them anyway. Yeah, and I see that backfiring on people, because that's exactly what the judge thinks. That you're just trying to interfere with the custody decision by, you know, confusing the matter by going to another court. A lot of and we use domestic masters mostly, unless you're in a rural county. A lot of the domestic masters are really smart about this, and when they see an open case, they just bump it right back to the child custody or divorce judge or whatever, and they are actually able to consider and enter those kinds of orders when it does get referred back to them. So the only time the domestic masters will typically do it here is if there is no other case open, and then all kinds of weird things can happen. So I also heard, and I don't know anything about how this works, but I heard Arizona in some way abolished CPS and changed it, and I think what was that about? That was a few years ago, right?
Well, yeah. So, I don't know that it was an abolishment. I should get my husband here, because he could probably talk to us about it.
I heard about it. It was a big deal.
It's, you know, so they kind of, CPS still exists, but it's just called the Department of Child Safety now. You know, so the Department of Child Safety performs the same functions as the former Department of Child Protective Services. So, you know, as an attorney, there was no change for me. I think for me, it just seems like it was a name change. Administratively within the department, I don't know what that amounted to, but we still have, quote, CPS. It's just called the Department of Child Safety. They still do investigations. They're still involved in termination of parental rights cases. They do the same thing. So
then it was just like a publicity stunt almost, because I saw some of the videos from that governor. So,
Oh, yeah, yeah. I think that's all it was. I mean, because yeah, we still have the Department of Child Safety, and they still, they remove kids and do their investigations and have the caseworkers. So nothing's gone away there.
I was curious, do you guys have parenting coordinators? And I'm only asking because you're nodding. We had
Yeah.
a case come out about 4 or 5 months ago that said the parents can veto it now. If the
Mhm.
parents don't agree, the court can't order it. So
Mhm.
this is old news for you?
Oh yeah.
Oh,
Yes.
we're
Yeah.
here.
Yeah. So I think it was probably 2 years ago. So before, if the court could order the appointment of a parenting coordinator over one or both parents' objection, for
Right,
that matter.
right.
And a couple of years ago, there was a rule change, where both parents have to agree to the appointment of a parenting coordinator for that person to be appointed. So, as you know, I don't really know, but I would tend to think that now there are less parenting coordinators or who are involved in cases, because it's rare to get two people to agree, because they're footing the bill, and inevitably one person is saying I can't afford it, or the other person's going to abuse it,
Right.
or one person's saying this parenting coordinator is no good, blah blah blah, and I don't want him or her, so
It
yeah.
wasn't even a rule change over here. It just somebody just filed an appeal, and the Supreme Court of Nevada got a little annoyed and just published an opinion saying that's the end of that. People have
Wow.
right to access to the courts. I'm curious. Okay, I got a lot of questions. I gotta let you ask one or two.
Okay, yeah, I do have a question for you. So on this subject, because I want to know what similarities there are between our system in Arizona and yours there in Nevada, and I'm actually curious all over the country. But do you have court appointed advisors there?
Court appointed. We have the closest thing we have to what you're saying is court appointed special advocates for abuse
Mhm.
of neglected children. But is that what you're talking about?
Well, so a court appointed advisor here is a mental health professional that's appointed by the court, and they can do investigations. And so their investigations are similar to custody evaluations, but not as comprehensive.
Yeah.
They, so if there are allegations of abuse or neglect or something like that, the CAA, court appointed advisor, gets involved, and they can do home studies and interview the parties and interview the children. And then they give a report to the court, but it doesn't include all the psychological testing and background checks and all of that. So I'm just curious if you have something like that.
We definitely don't. Never heard of that. We
Okay. All
have
right.
evaluators, but I've never. That sounds interesting. I wonder, do you think it helps a lot? I mean, I have no experience with that.
Yeah, from my perspective, it does, because in Arizona, we do trials to judges, and we only have a few hours at most to present our cases at trial. It's a rare case where you get a day. So there's so much information to elicit. Often I find myself rushed. Often I don't finish my case.
Yeah.
Sometimes I get an hour or two. So when you have the involvement of a court appointed advisor, they write a report. So they help fill in a lot of the blanks for the court. They address all of the best interest factors in Arizona. So it is very helpful to me.
Okay.
There is a cost, the cost I think is pretty minimal considering all they do. I think it's like $500 a party, but it gives the court more information, and it really, I get that report prior to trial, everybody does, and then it helps me know, okay, this is really where we need to focus or hit upon, because sometimes you get a report that's in your favor and sometimes you don't.
Okay.
But overall, I find them helpful.
That's good. Yeah, I've
Yeah.
never heard of that. That might be helpful here too, especially when you mentioned the cost being lower, because we have a lot of poor people here. They can't afford attorneys. I think between 40 and 60% of the parents that appear in our child custody courts are unrepresented. And
Wow.
so they can't afford an attorney, much less custody evaluators, parenting coordinators, and all these other extras. And
Mhm.
sometimes judges will order it anyway. And that kind of leads me into another question, because there's a problem that we have here with judges ordering poor people to pay for the attorney fees of a person who does have an attorney. How
Yeah.
common does that occur in Arizona? Because that is one of the things that just grinds my gears.
I know. I know. I am seeing more orders for attorney's fees lately. Um, but in Arizona, judges have to look at two factors to make a decision about whether somebody's going to be ordered to pay. So one is the disparity in income between the parties. So if one party, well, and the other factor is the reasonableness of the parties. So say the court finds that the poorer person has been unreasonable, then the court would look at the incomes. And if the court saw, well, this poor person can't really necessarily afford to pay it, then the court probably wouldn't award the attorney's fees, in my opinion, unless that poor person had, their behavior throughout the litigation had just been so egregiously bad and in bad faith.
Right.
But I am seeing more attorneys' fees awards because judges just want to make a point, slap people's hands, and show them, there's a better way to do this than.
Yeah. The problem that we had in Nevada was, and this is most judges making the mistake of assuming that litigiousness is the same thing as harassment. And the Supreme Court here has clarified that litigiousness in and of itself is not a basis to sanction a party. They have to show. But most of the judges don't understand that, or they do and don't care. And most people representing themselves don't know how to appeal. So over the course of time, slowly but surely, it just became a habit. So this is something I had to deal with representing myself for so long, is 7 different requests for attorney's fees. And I was able to fend off 5, lost 1, filed an appeal and got it reversed. But then the last one, I stipulated on one of them because I got such a good offer. They were asking for a huge amount, and then I got it down to like 15% of what they were asking for. Had I won appeals at that point, I would have just fought that one too. But that was when I was ignorant. So.
Oh my God, that's terrifying. That is really.
That's exactly the word I use, because it terrifies parents into going away.
Yes.
And what I also try and tell now that I can talk to judges because of my other organization, one of the things I tell them is just because they've stopped filing doesn't mean everything's gotten better.
Right.
They've just stopped filing.
Right.
So your job has gotten easier and it's gotten better because they're not in front of you anymore. But don't assume that everything is hunky-dory. The child is still being abused into oblivion. I don't know. I mean, there are many cases where the abuser is the litigious party. But I mentioned earlier there's a viewer of mine who had a huge victory. He was not the litigious party, or sorry, the other way around. He was the litigious party, and his ex, who was diagnosed NPD, he had experts and everything. She had a diagnosis, so this is just his word. She was the one that wasn't filing anything at all. She was just abusing the kid, using extrajudicial techniques and tactics, and playing around with court orders and all that. And then he would have to file things, and then when she would respond, she'd say, "Look, he's a bad person. He's filing papers and he won't work with me." I don't know a lot over there, but this is something that happens here. We have it where the person who's trying to protect the child is the litigious person because they have no other choice.
Yes. Yeah, that's interesting, and it really can be spun against the person who's filing the paperwork and trying to protect. You're right.
Especially if they have an attorney, because the first thing the attorney says is, "Look, my client has to pay all this money. Poor client." The other guy doing everything for free, they're a bad person. Yeah. And that's what I saw the whole time throughout my case.
Oh my God, that's awful. Yeah. That is really terrible. Well, yeah, in Arizona, I think the court looks at the reasonableness of the positions as opposed to just litigiousness. So
that's good. Yeah, that doesn't happen here.
Yeah, that is awful.
And there's other states that have similar issues. But Arizona, I haven't really heard many bad things about at all, except for the CPS thing. That was the only thing.
Yeah.
So go ahead if you have another question. I've got a
well, let me see. Let me just look at the chats here. I'm trying to think what other questions I have. I mean, well, you know what, Alex, one thing that we talked about when we talked a couple of weeks ago was, how where you are, oftentimes when the parties have attorneys, that judges call the attorneys back into chambers and try to force a resolution of the case. So I don't know, I'm sure you've talked about that in your past live streams, and maybe that's something we can explore. I've had that experience in Arizona. I would not say that happens in every case. It's really more of a judge specific thing. There's certain judges who do call the attorneys back, and I think that different judges have different styles. And there was one in particular a couple of years ago who basically would say, "This is what I'm inclined to do. I haven't heard the evidence, but I'm inclined to do this, and you better go out and tell your clients, and I'm inclined to award attorney's fees to one side if we don't get a resolution." And so then really, what we have are agreements, which I think aren't truly voluntary. They're agreements that are entered into based on, coercion to a certain extent. which is really sad because, you know, there have been times, and I'm thinking of with respect to this particular judge, there have been times when my client said, no, you know, I want to have my day in court and I want to talk to the judge about this. And I remember in at least one case, we changed this judge's mind, like going into his chambers before court. He said, this is what I'm going to do. And we changed his mind, you know, so it is possible, but it's really scary for the person who's being told you're going to lose and you're going to pay attorney's fees if you take this to trial. So
it's not good. And it's okay. So the reason I tell the attorneys and the judges, they're telling different reasons, but the gist of what I say is that there's no way to review what you're basing your decision on when you do that. There's no record. And of course the response is no one files an appeal anyway, or none of these people can afford it, so it doesn't matter. But that's the wrong attitude, I think, because even if all that's good and true, the litigants still come out thinking, what the heck just happened? The litigants come out disenfranchised, and they forever, you know, will interact with other people and say, yeah, it's a scam, the system's a joke, I was railroaded. And if people feel like they didn't get their day in court.
Right.
So,
right.
And they're not thinking about that. I don't think they're thinking about any of those things. It's just, you know, let's get them in, let's get paid, let's get a decision, let's get them out.
Right.
And then there's other technical issues that come up that have to do with res judicata principles that won't apply. And the reason I say that, I hate to get technical, but a lot of times some of these people pay for experts and they pay for reports from psychologists and psychiatrists, and they put in $10,000 to $25,000. And then if there is nothing on the record, if there was no trial or evidentiary at all, you can't rely on that report later on when the other parent tries to modify custody.
That's right.
And
That's
so
right.
I tell people, you're going to have to call that witness if this comes back 3 years later, but they're going to have forgot everything.
Yep, that's right.
So it's almost better that if you paid all that money anyway, to just have a trial, so that if something comes up later, this is already a high conflict case and something's going to come up later. Someone's going to try to relocate or something, and then you won't have to call that witness back and have another report prepared. You can rely on, you know, res judicata principles and cite the transcript and all that. Here it's pretty bad here. I don't know if you have change of circumstances, but over here we only have change of circumstances if a parent has primary physical custody, which we're not really doing much anymore.
So can you explain, we do have change of circumstances here, but I'm not sure I'm following what you say when a person has...
Our statutes were written specifically such that if a person tries to modify custody, the change of circumstances requirement only applies if one of the parents has primary physical custody. Your state may not have this issue. You may just apply that anyway, you know, no matter what's going on.
We do.
So this is one of the things that frustrates a lot of people, and attorneys don't understand this either, is that if you have a joint physical custody situation, which most parents have now, because that's the way we're going, they don't have to show change of circumstances. And so you can still rely on issue preclusion, which is one of the two species of res judicata, but that only applies if you've actually had a trial or an evidentiary.
Okay.
So when you settle, what most of these cases settle, they settle like crazy, and you have people who pay all this money and put all this work, and then the judge just goes, let's go into chambers. I read the report.
Right.
And so none of that gets preserved. None of that's, I don't know, that's just one of the things that I try to tell people about, to be careful of, is when you have those chambers discussions and you just cut a deal when you poured all this money into that.
I think I think that's a really great perspective that most attorneys probably don't consider when they have a judge who's saying, this is what I'm going to do. And, you know, and I have to say, because I have had that experience that I just talked about, it is possible to change the judge's mind, because you just, you know, every time I do a trial, I am surprised by at least one thing that comes out. And, you know, sometimes it's that one thing that comes out that sways the judge. And of course, it doesn't happen in every case. But even if you don't sway the judge, like you're saying, Alex, you know, you preserved your record. And, you know, that is important for future proceedings, or if an appeal, if somebody decides to go that route.
And the thing is, I tell people, like, even if you don't want it to be a continuing battle, if you have a high conflict X, you just have to think to yourself, this is what it's going to be. Mm-hmm. And so you have to plan ahead for it. A lot of people struggle because they're always thinking, this is the last hearing. And so since it's the last hearing, I don't have to worry about anything. Just get this over with and we can move on. And then they're back again and again and again. And each time they tell themselves, this is the last hearing. This is the last hearing. And so each time they're making mistakes. They're not setting their case up for success in the future.
That is the absolute truth. And I say it over and over to people, this is a marathon. It's not a sprint, you know, and even if you go to court on one particular litigation or set of litigation and you quote lose, you know, it doesn't mean that you've lost the war. Maybe you've lost this battle. You know, you may end up in court a year from now or 2 years from now. And if a judge made certain findings right now that are to your benefit, even though you lost the battle, that could help you 2 or 3 years down the road, because you're going to be able to cite the judge to those minute entries, you know, where the court found that the other parents had, you know, abused the process or whatever, done something bad.
Yeah, and that's what most of my case was in the beginning. I had about 4 years of losing, and I could use, you know, for the next 2 years after that, I relied a lot on those orders denying to win my later motions. I cited orders denying in my motions, and the judge did use them, even though he lost. This is an issue that keeps coming back. What is wrong? And yeah, anyway, you're totally right. It's good to hear that I'm not alone on that, because sometimes I really wonder, because you know, I did have 8 years of self-representation, but it's nothing like what an attorney does, because you guys are in and out every day.
Yep.
So,
yep. So, you know, so I think the takeaway from that to all of you who have been in court recently or in the past and feel like you've lost, you know, just don't lose hope. Because if you're involved with an ex who is a high conflict personality or has one of those disorders, and you anticipate being in court again in the future, it doesn't mean that it's going to stay that way forever. These things are subject to change, and you don't know what the future holds.
right.
You know, but Alex, you know, another thought occurred to me, and I really would like to hear what you think about it, because I get a lot of comments from people and emails from people who say, you know, it could be a mother or a father, you know, but they say the system is biased against me. You know, the system sucks. The system doesn't work. The system fails to protect. And what are your thoughts on that?
Well, what I tell my viewers when they tell me that, I tell them 2 things. Is I don't really see a whole lot of bias, at least not gender bias, as much as I see self-representation bias. And even then, I don't think it's overt. But what I do see is incompetence. And it's not necessarily egregious incompetence, but it's there. And so I try to shift people's perspective from thinking the judge just doesn't like you or doesn't like your gender to maybe the judge just thinks of his job as a paycheck. Maybe the judge doesn't care that much about what happens in the case. And that's not the same thing as bias. It's really not. There's different ways to overcome that. And what I usually try to get people to do is change the way they communicate with their ex to make the job as simple as possible for the judge. So you almost have to be like a fake person when you're, you know, facing allegations and when your ex is baiting you, to try and make the job as easy as possible for the judge by having less text messages for him to go through, less crazy emails, and it also makes a sharper contrast. I try to get them to see it from the perspective that the judge just really isn't that interested in his job. So if you make his job as easy as you possibly can, you're more likely to get the outcome you want. And also, I tell people that just because you lost doesn't necessarily mean the judge believed everything that your ex said. And this is something else they don't understand. So they may think that the judge just ignored their evidence, but their evidence wasn't relevant. Or they may think that the judge believed all their ex's lies, but there may have been some other reason, some other controlling legal factor that forced the decision to come out that way. A lot of times people try to modify temporary orders, which I tell them not to do. And then they lose those hearings, and then they think I'm going to lose at the trial, and it's not true. That big victory that guy had, he got nothing. He tried to modify his temporary orders. He was denied. And then he goes to trial and he wins.
Yeah.
They don't understand the difference between a prima facie case and actually proving your case. They don't understand these little details. So I try to tell them how all that works. And it kind of, if they understand it all, they'll shift away from that. This is what their attorneys should be doing, but their attorneys don't do this.
Yeah.
And so they don't know. Their attorneys don't explain anything like that to them. They don't explain how we're not taking evidence at this hearing. Their ex is making all these allegations, and then something bad happens and they get an unfavorable temporary order, and they think the judge believed all of them. And no, they didn't believe them. They didn't even, no evidence was submitted, and that wasn't even really considered testimony.
Right.
So they don't get that. And so I try to get them to understand that. And usually it works.
Yeah. It's, I'm such an optimist by nature, and I want to believe, I went to law school, I invested my time, and this is my life's work, so I want to believe that the system works, and that the system is fair. Do I see unfair results? Yes, I do. But, and sometimes you do have a bad judge because, like bad anything, there's bad judges, right? And there are plenty of judges who don't care. I agree with you, or who are tired of family law and dealing with pro pers because they feel like it makes their life more difficult,
Yeah.
because the pro pers don't understand the law and they submit the 8,000 text messages, and I think they're sick of it.
Yeah.
But I want to believe that if you prepare your case the right way and present the right relevant evidence in the proper way,
Right.
that the right result will happen. And that doesn't necessarily mean that you're always going to get what you want or that you're going to win. I don't think anybody necessarily wins in these cases.
Right.
But, I like to believe in the system. It doesn't always work. It fails sometimes, but overall, I think it's a good system. It's just a matter of knowing what you need to do.
Yeah, I agree. And the approach that I'm taking, obviously, in Nevada is to try to get the judges to just sort of understand that their decisions need to be reviewed and they need to be okay with that.
Mhm.
And the non-family division judges are great about that. They already get appealed all the time anyway, the criminal judges and the civil judges. The family judges almost never get appealed, and so they just have this weird culture where they sort of become a law unto themselves, at least over here. So, right, I mean, I think that the system is great when it works the way it's supposed to work, and I think that when all of the judges understand their role and that they're supposed to follow the instructions of their superiors, I think it works better that way. Over here, the Supreme Court and the Court of Appeals. And I think, I mean, I'm an idealist, but I think that it can over time be, adjusted, and hopefully the not so good judges will be removed, which has been happening over here remarkably. We've had 2 judges removed for incompetence. Well, 1 judge removed for incompetence, and the other is facing serious discipline. And that just doesn't happen here. That's brand new.
So, and we've had, I think, 2 judges in the last probably 5 years who have been removed. And I don't know how your judges are removed, but we have, every couple of years elections where judges are, the voters can vote to retain judges or not. And so there was a couple who were not retained.
Right.
And I, from what I understood, these judges were not retained, or they were not retained because of necessarily rulings that they had made, but because of their judicial temperament and their treatment
being rude
of people. And in my experience, the best judges that I've ever had in my career are the judges who treat everyone with respect. It doesn't matter who they are, whether you're an attorney, pro per litigant, or a criminal defendant. I did criminal work in a past life.
Yeah.
And, the best judges I had, we'd go in for a settlement conference, and they would listen to the stories of the parties, because a lot of times people just want to say, this is my story, this is what's happened. And what I find is that when people can have their say and feel like somebody's hearing them, that they're more inclined to take a recommendation of a judge. And I think if a judge, who's calling us back into chambers and saying, this is what I'm inclined to do, if these judges would be willing to listen to the story, that we might have some more settlements than we otherwise would have, or voluntary ones anyway.
Yeah, that's true. Those are, you've got retention elections. We still have judges compete. They go toe to toe here. They aren't political, so they don't have a party. But I did, through my organization, I found out way back in the early 1900s they were. So this was interesting. Apparently other states like Texas still have political judges, elections where the judges are political. What I was talking about with removal was we have a commission on judicial discipline.
Okay.
Yeah, and they institute proceedings against judges, and these guys are the ones that remove judges for incompetence. These last 2 that I mentioned. Well, one of them removed, one of them facing discipline. They usually remove judges for obvious problems, like sex with a litigant, or stuff like that. Which is so obvious. It's like, that's great, but I mean, knows that, like or committing crimes like fraud and stuff like that. But the ones that were moved for or punished for incompetence was pretty eye-opening to me. I liked seeing that because they just haven't done that in the past.
Wow.
If the incompetence was secondary, they would do it. Like if there was a judge who was an alcoholic, okay, he was incompetent, but it was because he was drinking, and everyone reported him for that reason. The incompetence is often hard for people to tell as a problem because most people think whatever the judge says is the law must be the law because he's a
Yeah.
judge.
Yeah.
Yeah, we remove people during elections too, but because the people have no information, it's for silly reasons. Maybe if the judge is rude or obnoxious is one, but a lot of times it's because they like the other judge's picture better or stuff like that.
Oh, wow.
It's a
Yeah.
problem, and that's what I'm trying to fix with the site.
That's awesome.
The retention elections is a nice way to avoid all of that.
Yeah,
It
for
still
sure.
has people involved, and I hope you guys never get rid of that because I'm a firm believer that the voters are better at removing problems than the government is. Oftentimes, like the legislature in Nevada has never impeached a judge.
Oh,
Ever.
wow.
I don't know if Arizona's ever done that.
I can't say. I have no idea.
And
But
the
yeah.
judicial discipline is they're kind of in a straitjacket. They can only remove judges with clear and convincing evidence, and it's very difficult. So the voters are the most powerful tool at removing judges right now.
Oh, wow. Well, yeah, I like the retention elections because, the people, it allows the people to speak.
Mm-hmm.
And, judges, aren't the boss of everybody, and they have to be held accountable too.
Right.
And one thing that I often tell my viewers and followers that remember that your judge is a person too, and judges have their own set of experiences. You don't know how a judge grew up, maybe they grew up with an alcoholic parent, and so maybe they are more sympathetic towards somebody, who's suffering with alcohol. They may favor somebody or really be cheering somebody on, because I've had cases where, a parent was driving with kids drunk and, doing really crazy stuff. And the judge didn't say, okay, your time's going to be supervised. You're going to do testing, blah, blah, blah. And my client's like, what is going on? And we don't know. We don't know what lens that the judge is seeing the case through because they have their own experiences in life. And we have to be prepared for that. We have to be prepared that maybe they're having marital problems. We have to be prepared that maybe they're a victim of domestic violence, or maybe they have breast cancer,
Right.
and they're just having a bad time in life. So on top of, trying to satisfy the judges and follow the law and blah, 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 we're dealing with this unknown set of stuff that they have going on in their life or their past. So, it's a really complicated thing that we're doing in the courtroom and that you're doing in the courtroom as pro-pers.
Right. Pyrie made a comment that brought something to my attention. He says that self-representation bias equals gender bias because allegations of abuse equals a free attorney. We don't have that here in Nevada. Allegations of abuse don't give a person a free attorney, but some states do have that. Is yours one of those?
No, we do not. If the parties end up in termination of parental rights case, and that would be not in family court in Arizona, that is in juvenile court.
Okay.
Then, so if the court's seeking to terminate one parent's right, that parent does get a free attorney.
We have that here, yeah.
Yeah, it's not abuse allegations, though.
Okay, yeah, there are some states that do that, though. I think one of them is Indiana, and I've heard some of the others on the Eastern Coast that do it too. So it does cause people to just make up those allegations on purpose just to get a free attorney.
That is awful. That is just terrible.
I don't think the legislature thinks some of these things through very clearly.
Yeah, and yeah, you're right. I mean, they really have to think about how the dominoes are going to fall. And if you're not thinking 3, 5, 7 steps ahead, then all these unintended consequences happen.
Yeah, if you read Falcone v. Secretary of State,
I haven't had the chance to do that yet, Alex.
That's what happened. The people are now abusing the confidential address program just because let's get a fake address and hide, and then they use it in court. And then they try and say that they're actually a victim because the Secretary of State gave them a fictitious address. But in actuality, it's a loophole.
Oh my gosh.
And that's what's crazy about it is my ex got TPR'd for severe abuse and neglect. Yet she hid from CPS using the fictitious address. They couldn't even find her. So she
my God. That's
the system to abuse the child.
It is ridiculous. I'm going to step away for 1 second. I'll be right back. Okay, I'll be right back, guys.
I'll check some of the comments. So let's see what we got here from everyone. Case law of the case. Biskino, I have a video on the law of the case. You should check it out. It's something that triggers when you win an appeal. It doesn't ordinarily apply. When you win an appeal and the case is remanded back, The law of the case doctrine will control on that issue going forward. Let's see here. North Carolina, or Rochelle says she had a court order for GAL involvement in 2016. Volunteer lawyer that in real, I think you're saying in reality, charged you $250 an hour, even though they were a volunteer. Never followed through with the report info. Yeah, Rochelle, I talk about that problem in the video custody evaluators. We got Karen. Actually, I think I also talk about it in the video Guardians ad litem. Both of those videos. Karen says DCS has closed case because no physical evidence. And okay, yeah, don't use DCS as a custody court, Karen. They have a completely different legal standard. And also the whole thing about the lie detector test, that's kind of nonsensical too. They shouldn't, base their decision on that. Watch my video, Abuse and Neglect Proceedings, and I explain a lot more as to why I don't recommend people using DCS when they have a custody case open. Biskino says, oh yeah, Biskino's pointing out that that's a problem. Let's see. Yeah, Biskino, testimony can be filled with lies, but it's there on the record and it's evidence. Remember, just because we recognize that the system is a certain way doesn't mean we agree with it. I talk about my disagreements with precisely what you're saying in the video Clear and Convincing Evidence, which is a legal standard I think they should use more often in child custody cases. But unfortunately, the system isn't that way. And so I don't know about Wendy, but my channel is geared towards people winning their case the way the system is right now, rather than ideas as to what we can do to change and fix things. So Wendy's back, and the last comment I'm going to use is Apyrutes. The system is not fair, bias is baked in, it's fundamentally broken. Apyrute, I talk about that in my video Discretion. I think bias bleeds through in areas where the judges have discretion. I don't think that it happens in the sense of the judge completely violating laws that they know exist and control them. So you should check out my video Discretion, and you can see sort of where I think that comes from. And I don't know if Wendy agrees, but what I was just saying is that I think bias, if it does come through, when it does come through, comes through in the areas that the judges have discretion. And that's one of the reasons why I don't think that the judges should have as much wide latitude, as wide a latitude as they do in the family court system. And in part, I compare that with other areas of the law. Other areas of the law where moneyed interests are cloistered, they do not give the judges that much discretion. They lobby very carefully for strict statutes controlling the judges. And I think it's very telling that these moneyed interests, banks, corporations, and rich people don't think that it's a great idea for judges to have so much discretion all over the place. Of course, you can't eliminate it completely. Right. And of course, with domestic relations cases, there's going to be some areas where you're just going to have more discretion than others. But it's a good thing, in my opinion, to have those debates occur not in front of the judge, but in front of the legislature, so that they can fashion statutes and rules that the judges can then follow and take as guidance. Yes. Instead, you have all these wide areas of discretion. And so what do the litigants have to do? They have to educate each individual judge. Correct. And that's expensive. Anyway, that's what I was trying to tell him, is that's where I think most of the bias comes through. I don't think judges are biased and they're like, I'm just going to ignore all of these statutes and screw them over. If there is a law, they will typically follow it. And if not, the Supreme Court, at least in Nevada, will intervene.
Yes, I agree. Yeah, I agree. But yeah, because the judges do have so much discretion to interpret. You get a party in there that the judge hates, and I've had it happen. Yeah. I mean, you know what? We can reason our way in or out of anything because we're all intelligent people. And, especially these judges, they don't like somebody, they can reason their way out of something. And then, the higher courts will say, well, the judge's discretion. The judge was the one there at trial, judging the credibility and the evidence, and that's the way it is. Yeah, it's exactly what happens here too. We defer on the facts. It's cool that have you used the Supreme Court a lot in your state? No, I have not, Alex. I've done just a few appeals. I've been in front of the Court of Appeals once. Yeah. And I honor you, and I admire you so much. It was a scary experience for me, and it's not that they were mean to me or anything, but I'm just not used to that, and yeah, it was scary. Maybe someday I'll get into appeals when I want to be, in court on a daily basis less. But I haven't used it much. No. Yeah, I got more interested in them when I realized it was more about the abstract legal principles and less about the facts. And I don't know, the more you get into that, the easier it gets, because you're detached from the facts of the case, and it's just purely academic up there. And I love that stuff. Yeah. You know, like I said, my background was as well, I started as a prosecutor, then I was a criminal defense attorney.
Yeah.
And as a criminal defense attorney, um, I did jury trials. And so I am more of an emotional, touchy-feely person. So I feel like, at the trial level, it's a lot of it's about the story that you create and the emotion, if you can, communicate the emotion to the judge or sway the judge with emotion. It's difficult a lot of times. And I know at the higher court level, it's less about that.
That's way less. They don't care. Not here.
Exactly. Well, I don't think that they do here. And, probably most of the judges that I'm in front of are too smart to be swayed by emotion. But a lot of preparing the case is storytelling and creating your theme and your story. And that's what I love about the trial work. I consider myself intellectual, but not that intellectual where I love analyzing sentences in cases.
Statutory construction is how I won 3 out of 4 of my appeals.
That's awesome.
That's what it was. It was you didn't follow the language of the statute, plain language rule and all that. That's how I won 3 out of 4 of them. The fourth one was ridiculous. The judge let a non-attorney represent a corporation. So I said, you can't do that.
Oh my God, I have so much admiration for you for wanting to do that and doing it.
I think it's the best way to help the most people, because when you win your own case, you just help yourself, which is what you're there for. It's expensive. You're paying all that money to win your own case. Yeah. But you can also help other people when you win these appeals. Even when they don't publish, they're persuasive authority in Nevada. And even when they don't publish, the judges do talk to each other.
Yeah.
And of course, when they do publish, it definitely changes things.
So let me ask you this, Alex, because this might help people who, really do want to follow the higher court decisions, which they should be, and I should be doing a better job of it. Luckily, I belong to a listserv where we share these things with each other, But how would you suggest that people follow this stuff? Like, how can they get their hands-on decisions, when they're published or shortly thereafter, so they can be up on the law as it's evolving and they can incorporate that into their cases?
Well, one of the things I tell people is they have to watch a lot of the videos. So a lot of pieces have to fit together for them to really understand what the point is of doing that. Most people think that they're there to talk about their case and their case only, much like Judge Judy, which they see on TV. So what I tell people is you have to look at statutes, rules, and case law before you can even understand what the point is of reading published decisions, because those decisions are based on statutes and rules and previous published decisions. And the other thing I try to tell people is you have to make the case bigger than you. So when you're arguing something for yourself, you have to think, how would that fit in when it applies to everyone as a rule? And if you can't pull yourself out of your case and look at it as something that would kind of work for a lot of people, of course, this is all fuzzy. I'm just trying to get them on the road to understanding how judges are thinking. It's difficult for me to get them on that road. Oftentimes my pattern is I take emails from people and I take comments on my videos. And when they ask these questions, I refer them to other videos where I talk about authority and statutes and rules and how that might control the case. And most of the time people end up getting funneled ultimately towards the end of these lines of questions, the ends of these email threads. I end up funneling them to my videos on how to file an appeal, and especially on the standard of review to understand how their case is reviewed. But it's not a really quick 1 or 2 sentence thing that I can do to get them on that path. It's often a dialogue, and it goes over the course of weeks of them communicating with me and me citing different videos, which in the videos themselves, I end up, eventually they get led to the appeals, because that's the end of the road. That's where the road ends. When you follow everything that you're supposed to follow and you're still not winning, the judge is making a mistake, which is, it's sometimes where you end up at.
Yeah.
I hope that makes sense.
It does. Yeah. It does. It does. It's there's so much to navigate when someone's doing this case on their own. It's a lot of balls in the air, a lot of juggling, and even I can tell you, even as an attorney who's been doing it for 20 years, it gets overwhelming. I don't say this to discourage anybody or tell, so you out there listening can say, oh my God, well, Wendy gets overwhelmed. How am I going to do this? It is possible to do. You just have to really break it down, take a deep breath, and just do it step by step.
Yeah, there's 2 comments asking for help on how to do it. Apiryu and Karen, I would say watch my video, Statutes, Rules, and Case Law. And I'm sure Wendy has a slew of videos on it too, if you want to give them a few to go and look at.
I don't.
Okay.
Maybe I should.
Well, I was just assuming that you had that as part. I'm sorry, I didn't know.
No, that's okay. That's okay. So a lot of my videos are, dealing with just the best interests of the children and how to prepare your case. I have a lot of videos that are dealing with navigating the courtroom itself, meaning how do you prepare witnesses, how do you get ready for court, etc. I don't talk a lot about, standard of review and abuse of discretion. I don't. That's not my strength.
Yeah.
Because I don't do a lot of appeals.
Yeah.
But it's really good. So I focus on what I consider my strength is doing the work at the trial level. But Alex is really opening even me up, to think more broadly. And
Yeah.
you guys should be thinking that way too. So it's good because I feel like Alex's channel is an awesome complement to mine.
Right.
I really teach the nuts and bolts of how do you do it? How do you do it?
Two of my humongous weaknesses where I haven't even done a video is questioning witnesses, cross-examination, cross and all that, and also rules of evidence. So those areas, it sounds like you have some videos on.
I do.
And those areas I have nothing on because I don't know what I'm doing in those areas. So those might be something for my viewers to look at, is look at Wendy's videos on, because I get questions on that, and I never did that. I represented myself for 8 years, and I had one serious evidentiary hearing, and I hired an attorney for that one hearing, and I won that one.
Good.
So I didn't have to do it. So I don't know. If I would have had to do it, I would have looked into all the details, but I never did because of those reasons. So
yeah, those are my favorite parts, just actually doing the trial work, preparing your witnesses, preparing yourself, preparing your cross, organizing the direct.
Right.
That's what I love doing.
So here's another problem area in Nevada. How is income imputed for the purposes of child support in Arizona?
So how is income imputed? Okay.
Or how do judges impute income? I guess that might be a fair question.
Okay. So, well, I will tell you that if somebody is not employed, then in 9 out of 10 cases, the judge is just going to impute somebody minimum wage.
Okay.
That's what it is. Say there's a situation where Joe last year was making $50,000. And then all of a sudden, he quits his job or he gets laid off and he's making $30,000. It's possible for the judge to impute him at the prior higher wage if the judge finds that underemployment is a voluntary thing, meaning that Joe purposely underemployed himself, or Joe hasn't looked for a new job in the field that he's trained in and experienced in where he could make the $50,000 a year.
Right.
So a judge could possibly impute that higher income. It does happen. So, if a judge feels that the unemployment or the underemployment is purposeful, the court could impute at the higher wage. I don't know if that makes sense.
That makes absolute sense because that's what's happening here.
Yeah.
And it's frustrating because the judge is supposed to make 2 findings and they're only making the 1 finding. Well, what you described was the way it's supposed to work. We have judges here who are imputing income when somebody is underemployed or unemployed, and they are not going into the second prong, which is to determine if that underemployment or unemployment is for the purposes of avoiding child support. That's the language of our statute. And it's routine. And it drives me nuts because when people appeal it, it reverses. But again, who appeals these things?
Right.
And,
well, yeah.
We actually had a child support committee that was formed here about a year ago. And there were a few of the hearings that I went to, and I brought up Arizona's case, Little v. Little. I don't know if you know about it.
I know about it. I don't remember. I don't remember what it says, but I've heard it, Alex.
I told the committee, you guys need to go to Arizona's Little v. Little and read it carefully, because in Arizona, your Supreme Court actually broke it down into 3 different categories. I thought it was really insightful. They had one category which discussed the good faith analysis, like if somebody's lowered their income in good faith. They had another one which was really strict, where you had to make money to support your kids, even over other choices in life. Then they had one that was in the middle of the 2. Anyway, I thought it was interesting because you're in Arizona, and the best case that I found was Little. And they actually put it up on their website.
Oh, wow.
Yeah, they're going to follow Arizona on that. But that is a big problem that we have here.
Well,
imputation when it's not appropriate.
Well, what I tell my clients, especially if you're the one who has really been laid off, so for example, a few years ago, I had a former, he was a professional basketball player, and he could not get work. He couldn't get a contract. His contract ended and he couldn't get a contract. He was looking and looking and looking. So all of a sudden, he had this huge income, went down to a low income, probably a pretty good income for most of us. And he wanted to adjust child support, which was formally calculated at California, according to California's guidelines. It was super high.
Oh,
we were trying to get it changed, and the judge said no. The judge said no. I don't think the judge liked my client. But anyways, I got off topic or off, track. What I was trying to say is that if you're the person who has been unemployed, because certainly there are layoffs that are legitimate, I always tell my clients, keep track of your efforts at trying to find new employment. I want a binder of all of your applications, of your resume, of a log of all your contacts, to a person, an employer, of all the interviews, because when we go to court, we can show that you're making a good faith effort at trying to find that new job. And if after, months of trying to find a new job and you can't, I think that would be enough to show the court that you're legitimately trying and you cannot get a job at that higher former income.
I could not agree more emphatically with what you're saying, because, and this is rooted for me in the principle of people sometimes go through these crises. It's so normal for people to have a good job and something to go wrong, and now they're not earning as much. That happens. And when two couples are together and that happens, they make it work. But when two couples are split up, all of a sudden that one person is like a wage slave. It's not that they can just voluntarily, decide I'm not going to work anymore. But the court should recognize that in some situations, this can occur. And when it does, you have to lower child support.
Right.
Because if they were together, that's what would happen. Their income would drop and they would have to figure out how to make do. It's such a normal thing. But the judges just get stuck on this idea that now, since you're split up, you can't go through these things anymore. You need to always be sure you make this amount of money. And if not, you're going to jail.
Right.
Which leads me in that thing about making sure they keep their work history, work search, and all that. That's such a big thing that I tell people too, because you don't want to rely on the wisdom of the judge. A lot of them don't have this wisdom. So unless you really show them, unless you're in their face about how much you've been trying, it will most likely come against you.
That's right. And yes, so if somebody's unemployed and you're trying to find unemployment, what you need to show the judge is that your full-time job is now trying to find a new job. Right. And that's what it should be.
Right. And that's it. And if it is, then your child support needs to come down. That's
exactly.
That's what happens.
I agree.
And the other thing that I tell people the same thing when they're being facing contempt of court for non-payment of child support. The case law in Nevada is clear. You can't be put in jail for not paying child support. You can only be put in jail for not paying child support because you haven't been trying to. If you can show that it's a standard, contempt of court principle that if it's not voluntary, you can't be put in jail. That would be a debtor's prison. A lot of people say we have debtor's prisons. I'm like, no, we don't, not on paper. There are judges who don't understand the law and they put people in jail and then they set these purge amounts and they don't understand the difference between civil and criminal contempt and how the purge amounts are supposed to work and the key and all that stuff with contempt. But on paper, that's not supposed to happen, and you can challenge that and get out on appeal. But for you to do that, you need to really show that you're not paying because you can't. You're trying.
That's right.
This happens a lot in Nevada too. Those two areas are the big ones, and the litigant does have to have their crap together.
I agree. Yeah,
well, against the grain.
It's so for us, the contempt, it has to be proven that it was willful and contemptuous.
Yeah.
So that's what you're saying. That a person will be held in contempt if they have the ability to pay, yet they have not been paying.
Right.
That's what it boils down to in Arizona.
Right. Oh my gosh. Shady activity with proposed orders. Do you ever see that? Especially with non-attorneys.
So can you be more specific?
You have proposed orders in Arizona?
Yes, we do.
So I've seen this happen when somebody's unrepresented and they go to court and they work their case and then the other attorney's ordered to prepare the order because they're not an attorney. And then that attorney omits language. Or in some cases, the attorney inserts language that shouldn't be there.
Yes, we do have that situation. I'm dealing with such a situation now, and I wasn't involved in the original litigation. This litigation goes back 10 years.
Of course.
And my client, according to the original decree, had certain obligations under that decree, which now should be over.
Right.
And in one part of the proposed order, there was a change made to that proposed order that was handwritten and signed by both parties, but in the actual, so what it was a stipulated order. So in one part of the order, it contained the parties' agreements.
Right.
It was a stipulation. And then the second half of the document was the actual order of the court, if that makes sense.
It does, yeah.
So in the stipulation, the agreement was changed, yet in the order, the agreement, it was not.
Oh, no.
So, yeah, so I think we're going to end up having to go to court because according to the agreement that was made, the obligation should be done by now. But according to the order, no. So I don't know what's going to happen there. It's all in the same document, which I think is helpful to my client.
Yeah, that is going to be helpful. Hopefully that gets fixed, and that's sad. Yeah, I know. I always hear about it like that, where an attorney says it was a case before them, or the party was unrepresented before. Mm-hmm. Because oftentimes when an attorney is on a case, the other attorney won't try that kind of shady stuff.
Yes.
But when there's no attorney on, that's when it happens.
Agreed and agreed. You know, and there's certain language. Okay, there's certain language that I'm okay with. So we had a settlement conference in a certain case recently, and the other attorney was to prepare the paperwork. And I said, yeah, you know, it's okay to just kind of fill in some of the blanks in the normal boilerplate language. Well, I get back her proposed agreement / order, and there's more than just boilerplate language in there. There's language about, you know, that I think is material language.
Right.
And so yes, that happens, Alex.
I really wish they would put that in the rules of professional conduct, just because, you know, the case, you know, attorneys are supposed to do that kind of stuff when they're arguing the case and they're filing the papers and pleadings. But once everything is done and over, that's a really vulnerable spot to exploit. That little piece at the end where you're preparing the order for the judge. I wish that they would get in more trouble when they mess around with that, just because it's kind of like it's an area that's so easy to exploit. And then once it's exploited, oh my God, the litigants that have messaged me about it just can't believe it, because they won their hearing and something wasn't put in there, and they're just like, what was the point of all that stress? Mm-hmm. And then you win, and then it's gone, just over that teeny tiny little thing I didn't know about at the end, which is why it's so risky to not have an attorney.
It is risky because often, you know, what I've learned this as an attorney, you don't know what you don't know. You know, you can be stepping into a huge hole with the proposed order, and you don't even know it because you don't know, and you're not going to know until a year later when the issue comes up, and you realize, oh crap, I entered into this agreement, and I didn't even know I was doing it.
And because you just assume it's been prepared consistent with what the judge said.
That's
Don't
right.
read anything. You need to read that thing carefully. I was going to ask you, do you guys set hearings routinely anytime a motion's filed? We have one district that does, and then we have all the other districts that don't. They only set a hearing if there's adequate, what they call adequate cause for one.
There's a couple of different types of hearings that we have, evidentiary hearings. So there's the temporary orders hearing and then the final evidentiary hearing. Mm-hmm. And we pretty much get either of those two hearings when we ask for them. You know, if there is somebody's asking for a modification of an order, custody, parenting time, then you have to convince the judge that there has been a substantial and continuing change in circumstances.
Before they'll set the evidentiary.
Correct. But I will tell you that I don't even know if judges here even look at that. Because pretty much get hearings on all of it. I'm careful about telling my clients, you have to make your case. You know, you have to make your case on pleading. And it's that prima facie case that we're talking about, right?
You pronounced it wrong.
Well, I don't know. I probably pronounced it wrong. I think there's different ways. Latin.
Yeah.
So you have to, or prima facie. That's another way.
That's the one.
You have to make that case, because I have had people who've come to me doing it themselves and say, hey, you know, I filed a motion to modify and it was just dismissed. Well, you didn't make the case on paper. So you got to fill that initial pleading in with as much detail as you can about why you want what you want.
Yeah, I think it's better the way that the judges in the other districts do it. So Vegas is in Clark County. They're the one that they routinely set hearings for everything. Mm-hmm. And I think it's better for the litigants. It saves them money when they're, you know, when a paper is summarily denied, because then they can go, you know what, this wasn't ever built up for a hearing in the first place. There was nothing in here that would have entitled me to relief. So they can decide I'm just done, I'm going to walk away, or they can clarify it and correct it and then refile it and see what happens at that point.
That's a good point, because I really think it forces people to think through. You have to think through why you want what you want, and that's big for me. I ask people when they come in to see me, why do you want what you want?
Right.
What is it that you want and why? And you have to articulate that. You have to articulate in writing, and you have to be prepared to articulate that in person to the judge. So this is something that requires a lot of consideration and upfront. And maybe it seems like a step, or I feel like it's a step that a lot of people just want to kind of skip over and file their paperwork.
They just want to talk.
Yeah.
The talking is expensive. I always felt it was unfair. I never was the type of person who was like, I'm just going to make my ex pay all this money and haha, I'm going to win. Right. So I would always put I would put together detailed papers, and most often I wouldn't even ask for a hearing. A lot of the questions were silly, like, can we split, our income tax refund? Mm-hmm. When I did ask for a hearing, it was I had to prove some kind of facts when I needed witnesses to testify. And I always tell people that when you communicate to the court in writing, you are getting your day in court.
That's right.
That's your day in court. Most people don't see it that way.
Yeah.
And there's also people who claim that there's constitutional rights to, all this stuff. And you have a constitutional right to a trial if there's issues for a trial to actually determine. Yeah. If you bring issues that don't actually entitle you to relief, you don't get a trial just so that the other person can go through it for nothing.
Exactly.
So I like it when states do, summarily deny these things without hearings, unless there's a cause for one, But Clark County doesn't do that, and I think it costs the litigants a lot more money just to go to hearings for fun.
Probably, you're right. Well, and one comment I want to make on, making your case on paper, I want to tell people that it's just absolutely important to be completely correct in every statement that you're making, in every pleading that you're making. There's a way to write persuasively without misleading the court. If you mislead the court and the court determines that it's been misled, then you're going to lose all of your credibility. The court is never going to believe anything that you have to say again, and it's going to prejudice you as long as you have that judge. Right. So you want the judge to know that he or she can absolutely rely on everything that you're saying as fact. So if you say a certain order was made in the past, well, you better darn well make sure that the order said what you said it said.
Yeah. You actually answered all my questions. I can go through the comments, or you can ask me a few.
Oh, no, that's okay. And I haven't been looking at the comments.
Me neither.
Because I have them here on my phone. I didn't want to be distracting people by looking down. Hi, Christine. I see Christine on there on vacation. She wanted to say hi.
Oh.
So I see, let's see, there's some people are talking about discovery and things like that. Did you do a lot of discovery in your cases, Alex? Did you do subpoenas? Did you do interrogatories, requests for reduction, depositions? Did you do stuff like that?
I did not do depositions. I did do requests for admissions, I did interrogatories. I have videos on both of those. I also did do subpoenas and subpoenas ducus tecums. I also did have to compel a witness to appear. I compelled a witness to I can't remember. They provided me something I needed. It was a teacher. They wouldn't do it, and then I filed a motion to compel against the teacher, which sucks doing. But obviously it wasn't a waste of anyone's time because the court did give me primary physical, sole legal, and then TPR. So I needed that information. It sucked to have to do that.
I have a question for you. What is your viewpoint on quote reluctant or hostile witnesses? Oftentimes, speaking of teachers, teachers have such great information about children and what the children are going through and what children may or may not be doing in one parent's care or the other parent's care. And, and I would love to have more teachers as witnesses, but I find that they're reluctant witnesses. And when it comes time to go to trial, they often don't want to.
Here's what happens. And this happened in my case. And so my attorney excused all the teachers at the last minute and just went with the dentist and the hygienist, and we won. Mm-hmm. What I try to tell the witness, and this sucks because I'm a non-attorney, so it sounds weird coming from a non-attorney, is you're not going to be asked to say who the better parent is. I just need to ask you certain questions of fact. Was this paper turned in? Did she show up at this, and no one's going to say, who do you think is a better, parent? And that does sort of calm them down a little bit. But as I mentioned, they still ultimately didn't want to show. They freak out. They're nervous. I think if you need it, you should just compel the appearance, because especially if you're not asking them, do you think this person's good or bad? If you're asking them questions like, on this day, what happened in class with this parent? You know, if it's something like, you know, they threw a chair across the room, you just need him to state the fact and then just get him out of there. Another thing I try to do often is I'll tell the witness, you know, if you don't want to go to court, prepare an affidavit. And I know that's not enough, it's hearsay, but what I will often do if there's like a hearing on law in motion prior to the evidentiary, I'll tell the judge, I have a witness, they prepared an affidavit, they don't want to show up in court. I'll compel them to show if I have to, but maybe my ex and her attorney will just deem this admitted, because I'm asking if this person will come and testify as to their absences. And if they want it, it'll work where they probably won't want to say, no, we weren't absent on those days, because they'll look like an idiot when it comes into court and the attendance keeper or the teacher says, yes, they were. They'll probably say, well, we'll just admit that. And then you don't have to bring the witness. There's tricks that you can use to keep a witness from having. I don't know if you've ever done that before.
I have. Yeah, I agree that there are certain stipulations that both parties can make and really should make. And I think that if a certain party is unwilling to make a stipulation, like the one you just mentioned, that would go to unreasonableness of position.
Yes, you would get attorney fees if you prevailed, and it blows up on, you know, it blows up in their face in court. A lot of times attorneys won't let you provide emails and reports and stuff because they'll say it's hearsay. And that's one of the things that I'll try and tell people to do is subpoena them. And then when you get there, when you get to a hearing before the evidentiary, you can bring it up to the judge and say, this is kind of ridiculous. The guy sent this email. They're not, are they going to admit it, or are they going to make me call him? And then the judge will make a note of that and say, you know, if you guys are going to make him come to court and he says that he sent that, and it pisses them off. The judges don't like to see people's time wasted.
Exactly. Agreed. Professionals, yeah.
Non-attorneys don't understand the point to all that, and they don't know that. And so then the attorney can kind of go to court and say, well, I didn't know they were going to bring this guy, and they can't use that piece of paper. And now you're stuck at the trial.
Right.
So
it's, you know, and so there are certain things, you know, I understand not necessarily wanting to make your ex's job, quote, easier in the courtroom, but there are certain things for the sake of efficiency and judicial economy that probably you should consider agreeing to, like what we're talking about.
Yeah.
Because it reduces cost for everybody. It reduces the amount of time spent. And, you know, it's something to consider. It doesn't mean that you're a doormat if you're agreeing to these things.
I think it destroys your credibility too. If you refuse to allow like a report on attendance to get admitted, and you force a witness to show up, and it turns out that you weren't there 14 days, you didn't take your kid to school, your credibility is shot, and now you look like a huge jerk because you forced a person to come into court. So oftentimes that would be my trick, I guess you could say, is I would tell all the witnesses that I'd subpoena, you know, prepare this, you know, affidavit, I'll file it, and then I'm going to do the best thing that I can to get it so that you don't have to go. And I would use those when I show up at one of those hearings. I would say, look, they prepared this. This is good, right? Not a lot of them were, you know, big deals. The dentist, there was no avoiding, because she knew if she admitted that, she was done for. So there was no way she was going to agree to that, and the tooth decay and all that. And so the dentist would appear. But the dentist appeared and testified, and it blew up in her face because you really made it go all the way to that level. Yeah. So the judge modified custody.
That's a really good strategy. So do you, in Arizona, the court, or we as attorneys, do not have to insist on the application of the rules of evidence.
Oh, nice.
Yeah, it's really nice. You know, so rules of evidence don't apply in our cases unless we insist on the strict application of the rules of evidence. So that's not the case there.
Okay. Yeah, no, that's the default here. So over there, one of you can just say, we don't agree to the rule. We can just waive the rules of evidence or something like that. Or do you both have to agree?
So the presumption is that the rules don't apply.
Okay.
Yeah. Unless somebody files a pleading according to the rules of evidence, or according to the rules of procedure, which say we want strict application of the rules of evidence. And in that case, they do apply. And in 9 out of 10 cases there, the rules don't apply.
Yeah, you know, I tell people there's other states that do that, not just yours. And some people say that's a violation of the Constitution and all this. It's really not. You can do that. And what I tell people is this: all it really does is it moves the onus from your ex to you. If your ex is going to say, we're going to rely on this police report, Normally, they're not allowed to do that, but they want to do that. Or I'm not sure. There may be rules about like government documents kept in. I don't know. You could teach me about that. I don't know how that works. What I'll tell people is if you have a problem with a piece of paper, then you can go ahead and call that witness.
Mhm.
There's nothing preventing you from saying, you know, I think this isn't fair. It's just a letter from a doctor. From you going, I'm going to subpoena that doctor and ask him questions about this letter. In
Right.
fact, I told a friend to do that once. It was a psychologist who filled out a report saying that he thought that the children of their father should go with him for some time because he was a good person. And then so she subpoenaed that psychologist. He came into court, and the first thing she asked him is, did you know that he committed domestic violence on this day? And then on this day, and then on this day. And then now knowing these three things, would you stand by your letter? And the psychologist said on the stand, no.
Yeah.
So I just tell people it's gonna move the burden to you.
Right.
If you have a problem with some kind of hearsay evidence, call the witness yourself. It's now on you to do that. That's all it is. So you're gonna have to do the work. And if not, then that judge is gonna read that piece of paper and possibly use it against you. So that's all I say. It's just different. That's what
that's a great, that's a really excellent way to, shift perspective.
Yeah.
It's just a shift in perspective. So I love how you characterize that for people.
Yeah, most of the time, I think people, they think since I'm a non-attorney, I'm just going to attack the system. But the system worked. I didn't know how it works. I had to learn about it. And the system can work for anyone who figures it out. If you're acting in good faith and stuff. I never really got into the whole gamesmanship, like finding ways to drag things out and stuff like that. I never really got behind any of that. And some attorneys do that, but.
Well, that is definitely not me either. And there are times when I have potential clients who come into the office and they want to do that, or it's clear that they want a certain type of attorney that I'm not. And I have to tell them that's not who I am, and you won't be happy with what I do because I don't practice that way. And so you better be served by somebody else.
Yeah.
I'm a straight shooter.
Yeah. This is what you're saying right now is exactly why I tell people that high conflict, personality disordered, messed up exes gravitate to and find messed up attorneys because attorneys won't help them. It's not a coincidence that this happens. It's not a coincidence that their attorney is doing all these crazy, shady things because they've gone to other attorneys like Wendy and she said no. So they end up falling into this is how it happens. And you've probably seen it too. Bad clients attract bad attorneys because the good attorneys won't represent them.
Right. Absolutely. Yep. There's some red flags and I will not do it. I have done it. And what inevitably happens is at some point I end up having the finger pointed at me by my own client, and I end up being attacked by my own client, and I end up getting the bar complaint by my own client. Yeah, and I've decided a few years ago I'm not doing that anymore.
Yeah, they do turn on any other allies, not just you.
That's right.
Any other allies, and they backstab them, and yeah, that does happen. So I'm on the disciplinary committee, and I have my first screening panel coming up, and I see in the report stuff like that. I can't mention specifics, but yeah, the other big thing I see is attorneys tattling on other attorneys.
Yeah, for sure. I just don't need that stress.
That's good. Oh my goodness, we've covered everything. I don't want to take up your whole Saturday.
Oh, it's totally. I'm good. I mean, I'm good. I know you've been on half an hour longer than I have.
Yeah.
Which I apologize for. Again, everybody, I'm sorry to Alex, and I'm sorry to you. I apologize for being tardy.
Yeah, I think it's just that part of Arizona is in that time zone. That's what I think it is. And Google should clarify that because Google just says all of Arizona's in there.
Oh my gosh. Well, I messed up. My bad. And I'm so sorry. I hope that Alex will do another one of these.
Yeah, the next one, you'll have to do the next one so you can post a video on your channel.
Okay.
And it's way easier than I thought. You're going to like it. So.
Okay. Well, maybe you can show me. I'd love that.
Yeah, I'll show you. I'll tell you. I'll explain over the phone and stuff. I'm going to just probably take a look at, I'll probably just do like 2 comments, and I think that'll be it. I don't know if you want to find a couple.
That's good. Yeah, let me see. Let me see what I can.
Somebody right here wanting to join your 21-day challenge.
There's
Oh,
there's still people wanting to join the 21-day challenge. Well, so let me see. I'm sure I can make that happen. So if anybody who's interested in joining the 21-day challenge that did not get a chance, normally I wouldn't open it up, but because you guys are here on a Saturday morning and you're Alex's people, email me and let me know that you were on the live stream this morning, and I will figure out a way to get you in. I'm going to have to open up the offer again, but I will do it. It may not be till tomorrow sometime, but email me if you're interested.
Yeah, there is.
Oh, so and my email is, let me tell you my email. It's Wendy at commandthecourtroom.com. It's Wendy at commandthecourtroom.com.
Oh, what I meant to say, well, I just got distracted, but I was about to say people have been messaging me about your 21-day challenge.
Oh my gosh. And I was going to reach out to you, Alex, about that and tell you, that if you wanted to, you could let your people know.
Yeah, I'll post something in my community tab.
Yeah.
And I'll about it. It's probably something I would have done if I was still in my case is completely closed down. It's done.
Good. Good for you.
There was a question I got here from somebody. No, I can't find it. Oh, well.
Let's see, I've been bad about, you know what? I don't have my reading glasses in front of me, so it's like
Oh,
hard
here
to
it is.
see my phone.
Yeah, it's probably hard for you to see. When you do the live stream yourself, you'll be able to get the chat out, and I'll tell you how to do it, so you don't have to use your phone.
Okay.
So Matt Mitchell, yours is the last comment I'm going to take. You're saying, does a Supreme Court statute overrule a doctrine such as res judicata? The statute says a judge must consider abuse that's happened within the past 2 years, but res judicata was applied. Well, that's a complicated question because there's two types of res judicata: issue preclusion and claim preclusion. What I would say is, I'll answer your question again. If you watch my video, issue preclusion, watch my other video, claim preclusion, watch my third video, change of circumstances. And then after seeing those 3 videos, send me an email if you have more specific questions. But the Supreme Court doesn't really create statutes. They give opinions on what the statutes are trying to do and say and stuff like that. So that's the best way I can answer that for now. All right. Unless Wendy has a better answer.
No, I do not. I couldn't even follow the question because it was such a complicated question. I'm going to go watch those 3 videos, Alex. No.
The reason I got so attached to those legal doctrines is because you get de novo review on the law. So I would find laws to control the outcomes as best I could. So if you can apply some kind of legal doctrine to the child custody case and cut off access to the facts that the judge got to, you'll get an order reversing. It's one of the interesting things about the Supreme Court, because on the facts they defer, but on the law they don't. They will supplant the judge's decision with their own.
You're inspiring me, Alex. Really, maybe I'm going to start getting into appeals here.
The other trick, you want to use these because how unfair is it for your client to pay for all that stuff? You win a trial, and then somebody files a motion modifying and it all gets thrown away. No.
Yeah.
If you use res judicata principles because they're legal principles, you can get that reversed. And then the other, sometimes you can get people on judicial estoppel. I think they call it the estoppel of inconsistent positions, where somebody will cite something that's wrong and then they'll win on it. And then like a year later, they'll say, oh yeah, I was wrong about that. I want to change that now. Yeah. So the judges, you never know what they're going to do. Yeah. You cite judicial estoppel, now you can force them.
How does this, in Arizona, our judges, once you're a domestic relations judge, you're not a DR judge forever. They rotate.
Oh, okay.
They rotate every few years. So say you have one judge make a decision, on one set of facts, and then 2 years later we have a different judge. I would think those principles still apply regardless of the judge, but I don't know.
Absolutely 100% do.
Yeah.
And absolutely 100% do. And if a new judge comes in and just ignores all that stuff, that is so wrong.
Yep.
That is so wrong to what happened, how to just throw away. No. And if you don't bring up the issue preclusion though, and you get a bad ruling, you won't be able to appeal because the issue won't be preserved.
All
so
right.
you have to actually cite it and say, here's the 4 elements of issue preclusion, all 4 of them apply. This is another thing I bring up to people who get these CPS case. They file a CPS report and then they say it's unsubstantiated.
Yeah.
And then they go into court and say, well, that didn't happen because it was unsubstantiated. I'll say, well, you just show the elements of claim and issue preclusion. None of them apply. So the judge cannot be bound by that decision. And if the judge says, oh, I'm not going to, go to a hearing because CPS didn't find anything, that'll get reversed too. These things do reverse.
That's and that's one thing that I think I have seen judges in Arizona are onto. They don't necessarily follow the recommendations of, DCS, they will review the underlying allegations.
Right. Well,
You
there's humongous problems with it. Number one, the standard is so different.
It is, yeah.
And then number two, the other party wasn't up. There was no proceeding. The other party wasn't involved. So your investigators may have missed things. The other party may have litigated differently. And so under res judicata, you can't do that to them. You can't preclude them from bringing that up in court. And what the heck? O.J. Simpson got, taken to civil court, even though he was not guilty in criminal court. So it's not like I'm saying something that's completely brand new.
That's right.
Happens in like TV too. So
that's right. And so, that raises another thing in terms of like, the reports. You've brought this up during our live stream today. You have reports by professionals, by doctors, psychologists, psychiatrists, custody evaluators. And just because you get a report doesn't mean your goose is cooked.
Right.
Because there are ways to discredit these professionals and cast doubt upon their findings and get the judge not to follow them. So don't lose faith if you get a report that's not in your favor.
It's great to have an attorney for that too, because they can take the emotion out of it, and they can pick the report apart and find facts that the expert may have made that are based on nothing.
That's right.
Even better is it's easier to attack the recommendations because oftentimes they don't know the law. So they'll make recommendations that aren't consistent with the law. So one of the examples might be, well, this report has findings of domestic violence, but this expert is recommending joint physical custody. Well, it's nice that you're recommending that, but consistent with Nevada law, you can't do that unless you overcome this presumption and all of that. So you can beat them. I have a video called Beating Recommendations. You usually won't be able to beat them, but there is a chance you might. You should look into it and explore it. And if you have an attorney,
I agree.
That's a litigator.
Agreed, 100%. And I brought this up the other day. In my first year criminal law course, it was Professor Blakey, who was the creator of most of the racketeering statutes today. Robert Blakey, you guys should Google him. He was involved in the Kennedy assassination investigation. But so in law school, the way that they did it, where I went to law school, is they taught us by the Socratic Method. So the judges would, were studying a case for the day, and then they would call on somebody. And you'd have to stand up and talk about the case. They'd question you about the case and what if the circumstances or the facts were this way or this way, what way would the court rule? But what Professor Blakey taught me, and he said over and over again, is that despite, what cases may say or what rulings may be, you can find a way to distinguish your case. And if you don't, you're not being creative enough. You have to think outside the box. That is how new law is made, by thinking outside of the box. We would never have new law if somebody didn't think creatively. So even if the law says something, doesn't mean you can't change the law. And I think, Alex, that's what you're really involved with, is trying to change the law, so they really help people and address the needs that people have.
For anyone who hasn't learned about the Socratic Method, which Wendy just mentioned, you should watch a video. I didn't even do a video on it, but there's tons of videos on the Socratic Method. Like when we go through school and even college, we are mainly following instructions, and we are taught through like rote memory and stuff like that. Socratic Method is more of getting you to think. It's sort of creating your critical thinking skills and your ability to like logically analyze, which way you should go. And so I think what they do is they bombard you with questions. They'll ask you a question, you give an answer, they'll ask you another question. It may seem like you're being attacked even sometimes, but they're just trying to get you to think and go around, how to deal with opposition. It's a really fascinating way of learning. That's nothing that I ever learned in school. I learned about it afterwards.
Yes. And that is a fantastic way, as an aside, to prepare for your trial. If you have a friend or a family member or somebody like Alex or me who can help you. I practice with my clients and I play devil's advocate.
Yeah.
And I, don't attack them in a mean way, but, I say, well, you're telling me X, Y, Z, and this is the way it is. And so I question them so they can be prepared, for questions coming from any direction. So practice is important. Practice is important, and having somebody ask you those questions about different situations. So yes, the Socratic Method helps you think more critically, and you have to think about the other side. This is like a chess game. This is not a game, but you know what? The way my mind works now in all aspects of my life, even in my personal life at home with my child and husband, I think if somebody does X, 2 moves down the road, what is going to end up happening? if I do X, then what are they going to do? And then what am I going to do? And then where are they going to end up? You have to think this way. You can't just think about, if you do this, this is going to happen right now, right here today. You got to think again down the road. It could be months or it could be years down the road, but you have to anticipate their next move.
A lot of people say, well, then what's the point if it's going to take years? But I tell people, you're going to be there 3 years from now, kicking yourself for not 3 years ago setting yourself up for victory, because you're going to see the abuse and neglect your child is going through, and you're going to see that, you know, it's affecting your life too. So,
there's a proverb, it might be a Japanese proverb, about when is the best time to plant a shade tree. And the first answer is 20 years ago. But then when is the next best time to plant a shade tree? Right now, today.
Yeah.
So just keep that in mind, guys.
Yeah. All right, Wendy. Thanks for coming on, and we'll set one up where I'm on your channel and I'll teach you how to do it. It's so easy. You're
awesome. All right. Thank you, guys. I really appreciate this, Alex. It was super fun. And thank you guys for your grace and allowing me to be a half hour late. I'm so sorry. I apologize for having wasted your time, Alex, and your viewers' time.
I think this was one of my best videos, so it was worth it.
Okay, good. Good. Well, I hope that you all have a lovely weekend, and my husband went to get my daughter. She had a sleepover, and I'm taking her to dance and having some family time. So I hope you guys all do the same, and just thank you so much.
All right. Bye, Wendy.
Okay. Bye-bye.
Bye, guys.
Bye.